Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with the due diligence period. And what do you do as a buyer's agent if the buyer has sent an amendment during this time frame and you have not heard back from the seller? Well, as I've discussed in previous videos, the due diligence period is merely an option for the buyer to choose to proceed with the contract or terminate. It's really the option to terminate with no penalty. The buyer has until 11:59 p.m. at night, the last day of the agreed upon negotiated due diligence time frame, to choose to proceed or to terminate. If they terminate, they protect their interests with respect to the earnest money and not being sued for defaulting on the contract. So during this time frame, as previously mentioned in another video, a buyer can do whatever they want to do to make themselves satisfied that they are going to proceed. One of the things they can do is to have all various types of inspections done: independent home inspection, roof inspection, termite inspection, so forth and so on. Also, the buyer has the option of proposing an amendment to the seller to ask the seller to address concerns with the property. And in the GAR package, contracts package, this amendment is called Amendment to Address Concerns. And in the RE Forms package, this amendment is called Amendment During Buyer's Right to Terminate Period. Regardless, the buyer has the option to ask the seller to address various concerns with the property. The seller has the option of accepting that amendment, negotiating that amendment, or rejecting the amendment outright. But if you are a buyer, if you're representing a buyer, and the buyer has proposed that amendment, if you do not get it back signed from the seller prior to the end of your buyer's due diligence period, then the buyer either has to decide, are they going to proceed without the seller addressing those concerns and taking it as is, or do they want to terminate? If it is quote unquote make it or break it issues that a buyer absolutely cannot afford the house or does not want the house, if the seller does not address those concerns, the only option for the buyer is to terminate the contract, protect their earnest money. If you just need more time and you're not hearing from the seller, terminate, protect the earnest money. You can always rewrite a contract that same day or the next day. If the buyer is willing to accept the property without the seller addressing those issues, then proceed on. So here's the deal. If you have verbally negotiated with the buyer and with the seller, and the seller has said they are going to fix those things or address those things, it does not matter. The only thing that matters is you have to get that signed amendment back in writing, signed by the seller, prior to the end of the due diligence period. If you don't get it back signed prior to the end of the due diligence period, it's as if they have agreed to not address those issues. Only thing to do. One other thing regarding due diligence period. The due diligence period is only the option for the buyer to terminate. A seller has absolutely no termination rights in the due diligence period, which in the RE Forms contract is also known as the buyer's right to terminate period. So I hope that helps. Again, thanks so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.